Good afternoon. My name is Philippe Governier, and I'm here to talk to you, share the results of my research on judicial activism in a reformational perspective. And first, I would like to thank the organization of the conference for the opportunity to share my thoughts on the subject, and to thank publicly the friends of our study group on reformational philosophy here in the person of Victor, to say that they have given me an academic community of thought, and they have taken me out of my isolation, where I studied Doivert alone for a long time, and I found them, and it was a very pleasing experience. So, for starting, I want to say a few words on how my interest on the theme has emerged. I work as a legal assistant in an appeal court, and I face this problem daily. And also in Brazil, in the last years, we have faced many controversial decisions, mainly by our Supreme Court. And reading and watching and seeing the many Christian critiques of these decisions, I started seeing something a bit interesting. And I started wondering that maybe these critiques were a little interesting. And why? I started seeing that when the decision of Brazilian Supreme Court was aligned with Christian values, was contrary to Christian values, it was accused of being activist, of violating the separation of powers, of going beyond the text of the Constitution. And the hallmark here is the decision of 2011, if I'm not mistaken, that allowed same-sex marriage. But, on the other side, when the decision was aligned with some goals or some agenda dear to Christian values, such as the fight against corruption in politics, even if it went beyond the text of the Constitution, it wasn't doomed activist. It wasn't hallowed. It was celebrated by the same associations, so to say. And here I think of the decision of the same Supreme Court that allowed for the imprisonment of criminal convicts before their final judgment, requiring only a judgment by a court of appeal, even if the text of the Constitution said that no one was to be held accountable before the final judgment. And the Brazilian Supreme Court used some hermeneutical techniques that expanded the sense of the Constitution in a somehow activist way. But the decision was hallowed and celebrated. And I started wondering, criticizing judicial activism is just a way of saying that I agree or disagree with that decision. Means so. Or the only argument we can come about is the violation of the separation of powers. Is there a way of criticizing judicial activism in a Christian way, in a really Christian way, with more complex arguments? And here is where I started a research, independent research on the subject. There are many ways of doing so. I intend to do a biblical theology of adjudication and making a research on patristic sources on the subject, on the historical Christianity. But on this paper, I have a limited goal. I use reformational thought to show how the biblical ground motive of creation, fall, and redemption in Jesus Christ helps us to give a more complex perspective on judicial interpretation, decision-making, and therefore on judicial activism. And why? In order to have a more complex view of this phenomenon, and maybe give a better critique sustained by better arguments if we are to criticize this phenomenon. And to do so, I'll follow this line of thought. I will give a brief definition of judicial activism, what I mean by it, and I'll analyze this phenomenon with the three parts of our ground motive: creation, fall, and redemption. I'll try to stick it to our time. First, what is the definition of judicial activism I'm using here? It occurs, I've tried to reach a common definition from the various definitions of judicial activism. It occurs when the judges apply or use a very free interpretation of the terms of the law and expand its sense beyond traditional boundaries or acceptable boundaries, and doing so they use great discretion of power. They use more discretion, and sometimes without consistent hermeneutical patterns. And they sometimes substitute the written law with their own ideology or moral patterns, moral standards. And in doing so, most of the times, they tend to impose on the other branches of government some actions. They impose upon the executive the obligation to implement some public policies, for example, or they determine that the legislative legislate on some matters. So when this happens, the action of the judiciary is called activism. Okay? But see, this definition is a little bit dependent on some evaluative characters. It depends on the institutional design of each country. For a constitution might impose on the judiciary itself a certain amount of powers that allows it to interpret the law more freely or to impose upon the other branches some actions. And it depends on the theory of judicial decision that we adopt. Depending on the theory of decision we adopt, we might consider it good or acceptable that the judge goes beyond the text of the law. And even the reactions in society are different. Some might consider it good that the judge acts this way because he implements justice, human rights, or some might consider that the judges are not entitled to do so because the best forum, the best place to do so, to do this deliberation, is not the judiciary, but the legislative, where they are representatives of all sectors of society, or the executive in technical matters, for example. So, it's not only a matter of legal hermeneutics, the question of activism. And what is my question here? How can we analyze this phenomenon, this complex phenomenon, from a reformational point of view? And here we appeal to the three-part ground motive, the biblical ground motive of creation, fall, and redemption. Here in the creational perspective, what we have is, mainly I'm drawing from Diver's construction, we have an analysis of reality as as composed from multiple aspects. And here, Victor has already done part of my job here. Reality is composed of multiple aspects, each one with certain autonomy, not autonomy, but with each one with its own sovereignty from one another. Every aspect of reality and every social institution. This is relevant for our subject. But neither the aspects of reality, neither the social institutions are isolated from each other. For example, the juridical aspect. And I am really not fond of the translation of juro. I have never really enjoyed that. Juridical for me is better. The juridical aspect is not isolated from the other. So it has relations through the analogies to moral aspects or to economic, aesthetical aspects. It interacts with all aspects of reality. And social institutions interact with each other. Okay? The reality is a complex of elements which interact with each other. What's the consequence of this view of reality for our thing? Is that judicial decision making is a complex activity. It operates in all aspects of reality. And so, when a judge will decide a case, he's not limited to a formalistic interpretation. He's not limited to the interpretation of linguistic science or to a logical interpretation. He must consider historical aspects, social aspects of the case and of the law. He must consider the economic aspect and the harmonization of interests, and that is the meaning nucleus of the legal or the juridical aspect for Darwin, the harmonization of interests. It's even the defining nucleus of the public justice, as Victor has said. So the judge has a much more complex text than to interpret signs and decide the case based on their meaning. So, if that is his task, we could risk to say that there is some creational base for a certain measure of activism. And even if we consider that there are interactions with the moral aspect of reality, if moral aspects of reality come into the judicial decision making, there is a base for the judge to consider them. And this is not in itself wrong. The problem are the limits, as we shall see. But still inside the creational perspective, there are limits to the judicial function. And here we are still appealing to the separation of powers. So here's why I'm saying that the reformational perspective gives us a more nuanced view of the phenomenon. And here we have a first argument to limit the judicial function, which is the very presence of multiple aspects. If a judge must consider not only the linguistic or logical aspects, but only the historical, social, economic, that multiple aspects, they reduce the possible meanings that he can ascribe to a certain norm or to a certain case. That is, reality itself, in its creational base, already reduces the possibility of meanings that a judge can ascribe to a case. But there is the sphere sovereignty, which also limits the task of the judge. And why? Because the judge is an organ of the state, and as Victor has pointed out already, the state cannot interfere in the sphere sovereignty of other aspects and of other social institutions. So see, here we have two limits to judicial decision making that do not appeal to separation of powers. The idea of sphere sovereignty, indeed, does not even deal with the distribution of power inside the state. Okay. It tells us about the distribution of power inside society. So we have material limits to judicial function. So this is why I say we have a much more richer view on the subject. Here we have the perspective of the fall, and here is where we have a base for the separation of powers. Which is why the judge has a creational power to act. Okay, but as a fallen human being, his cognition and volition is affected by sin. So he can make a series of mistakes, as any other political actor, as the legislative, the executive. And here we have a Christian base for controlling the powers, and the separation of powers is one among others that were historically construed to limit the power of the state. So there's no problem in using the separation of powers as an argument, but not as the only argument. That is my point here. So we have a base for criticizing judicial activism through the idea of the fall. But it prevents us from divinizing the other branches of government. Oh, okay, the judiciary has crossed the limit, so let's give back the power back to the people through his elected representatives. We are following the same reductionism we are trying to avoid. We are committing a certain kind of ideology, as David Coises points out. We cannot do so in our critique. That is one of my points. And in conclusion, we go to the redemption perspective. And here we have two perspectives here. One is, again, we come back to Bavinck again, the idea of revelation. How are we to discern the governing norms of each sphere of sovereignty, of each aspect of reality, of each social institution, of its individuality structures? As fallen human beings, we cannot have direct access to that. We depend on revelation. If God does not reveal them to us, we are only seeking them in the dark. And here's where revelation and the redirection of our heart are necessary. But okay, people who haven't been touched by special revelation have access to some glimpse of truth through common grace. And when revelation starts operating in us, we can develop a certain amount of virtues. And here, the idea of virtues, it doesn't appear, I think, so in my studies so far, in the work of Dort or in reformational thought, so far as I have studied. But I think it's an interesting bridge to the virtue ethics, which has already appeared in some studies on judicial decision. It's an interesting perspective we can investigate. How to develop virtues that can ameliorate the judicial function. And the other perspective of redemption is the kingdom perspective. How the kingdom perspective, our future hope, the idea of the not yet, influence our already search for justice in this world. How the hope of an era, an age where justice and peace shall embrace, affect our search for justice now. And what institutions we can build now. How can we make judicial decisions now that resonate with a biblical perspective of justice? And here is where biblical theology would be more useful. And I just give an example of communal justice. This will, in a certain way, bypass the problem of judicial activism. Why? Because people themselves will decide their cases. But it's a kingdom perspective coming to resolve our problem. So, as a conclusive remark, I would like to highlight that my goal here was to go beyond a simplistic critique of judicial activism that is normally addressed to it in Christian circles, showing that with the use of the biblical ground motive of creation, fall, and redemption, specifically through the lens of the reformational philosophy of Dort, we can address a much more refined critique to the aforesaid phenomenon, entering a fruitful dialogue with contemporary thought, giving a much more meaningful contributions to society. See, many of the thoughts I've given here are similar to secular legal theories, but we are saying maybe the same things, but with a biblical foundation. With a biblical foundation. So, we are not giving a simplistic critique. And this is a much more complex task, but a one we must not evade, otherwise our critiques, no matter how correct they are, will be only words cast out in the wind. Thank you for your attention.
So we give you about 6 minutes for questions.
Okay, I'm open to questions.
Very much, the presentation was very good. in the Netherlands we have also judicial activism, but also a very big critique on the judge, which is not always good, as you also mentioned. But one of the incentives for judicial activism are international treaties. So the Netherlands is, for example, European Declaration of Human Rights or European treaties, and of course also international treaties. So wouldn't you say that then the legislative power, there is indeed the power to either bail out a treaty or adjust the treaty in order to prevent judicial activism? And wouldn't you say that the virtual approach would then be one of the most successful approaches to show that the churches have to apply certain virtues as temperance or moderation to not overstretch a treaty or to be careful in the interpretation? So these two elements, I'm curious what you think about it.
Thank you for the question. I'm not sure if I understood very much the first part of the question about the treaties.
Is that the power or to counter judicial activism? The key is actually in a democracy, in the legislative power. Because the parliament can always decide we should bail out of a treaty. We should get out of an international treaty that, for example, says same-sex marriage is a good thing, because the judge will just refer to an international treaty and say, I'm just applying what you accepted, right? At least in the Netherlands, that's how I read this activism. I don't know how that's possible.
And you say that the legislative bails out a treaty, and the judges say that this is an illegal conduct, or no, they bail out to counteract judicial activism. That is what happens.
So in order to overcome judicial activism, the key in a democracy is in the parliament, I would say. Because they always can say we get out of an international treaty, right? There is always a potentiality for that.
Okay. Yeah, I think in Brazil they are trying to do so, but we end up falling in a kind of trap. At least here, I don't know the system, the legal system in Netherlands, but here, for example, if the legislative tried to do so here, probably the discussion would end up in the judiciary, and they will say that this bailout is unconstitutional.
Because of the Supreme Court.
Yes.
Yeah, we got that.
Yes. This would.
The Constitution traps the discussion.
Yes. It ends up, every question ends up in the Supreme Court here. So we end up in a kind of trap.
But then it's a constitutional debate, right?
Yes, because yes, it's kind of yes. And I think the virtue part is still a further part of my research. But I think some virtues as moderation and humility would be a certain counterpart to activism, but still depends on certain individual characteristics of the judge, which is somehow important to develop it collectively. Maybe the formation of judges would be a more interesting approach.
Congratulations to the presentation, and I missed some analysis about the anticipatory and anticipatory analysis of the aspects. What you think about the function, the jurisdictional power of the state, and what you think about the limits to judicial activism?
Yeah, that was something I passed too quickly, but that's something that drew my attention in two senses. Because sometimes the critique on judicial activism is based on the sense that a judge cannot apply moral considerations in his decision. He must stick to the text of the law. And from a reformational perspective, that isn't so. The moral aspect, through the anticipatory analogy, it comes into the decision because it relates to the juridical aspect. So there wouldn't, in principle, be a problem. But the problem is that Doivre himself, he doesn't develop too much these things. We have to do some inferences from it. And the limit will be in the meaning nucleus of the juridical aspect. So a judge could bring these moral considerations to open up the meaning of the juridical aspect, but the core of the juridical aspect still will be the idea of retribution. He could not enter the discussion on if the action itself was moral or not, morally condemnable, but only such as the clause of good faith in contract law. This is a case where morals come into the law, but relates to the idea of retribution, to establish the proportionate retribution for the violation of good faith in contracts. It's a more complex relationship, but it's case to case. Doivre himself, in the text I developed a little bit more. In the final of his book, The Crisis of Humanistic Political Thought, he gives some examples of this interaction and of the possibility of state interference in companies or in enterprise law to implement public justice. This is the only place where I've seen him giving concrete examples of when state can interfere in sphere sovereignty.
Thank you for that. Multi-level social action theory and level complexity.